Study for the Bar in Your Car podcast.
We're your hosts with the most, Claude and Ma.
I'm Claude.
And I'm Ma.
And we're here to guide you through episode 19, Torts Product Liability.
That's right. This particular episode on product liability is built on some really detailed notes from Angela, who's a law student.
Yeah, we're basically, AI bots brought to life by her notes and, well, AI magic. We try to make these complex legal ideas a bit easier to digest for you.
We do. And Angela, she's a real person, currently studying law at George Mason University. She was actually president of the Graduate Law Students Association there, too.
Oh, wow. That's the one for LEM students, right?
Exactly. So her notes are pretty thorough, and they really form the foundation for what we're discussing today.
And if you find you have questions about the podcast content or maybe some feedback, you can email Angela directly. The address is podcast@studyforthebarinyourcar.com.
Good point. Also, Angela does freelance work as a remote law clerk. Yeah, so if you're an attorney, or maybe you know one who needs some help, ad hoc assistance with things like motions, complaints, writs, answers, briefs, stuff like that, you can reach her for that kind of work at hello@legalwriterandlawclerk.com.
Okay, good to know. So, today, product liability. This is a really big topic in torts, isn't it?
Oh, absolutely. It's crucial, not just for the bar exam, but, think about it. It impacts almost everything we buy and use.
Right. Cars, food, medicine.
Everything. And it really boils down to that fundamental question. Who's responsible when a product causes harm?
It's a huge area. So what's the plan for today? How are we tackling this?
Well, the goal is to give you a solid grasp of the key concepts. We'll start with the basics, what product liability actually is. Then we'll dive into the main theories of liability.
The big three, right? Strict liability, negligence, and warranty.
Exactly. We'll spend a good chunk of time on strict liability because that's, really central. We'll look at the elements, the different types of defects, manufacturing, design, warning defects. Then we'll touch on things like product misuse, what damages you can actually recover, and wrap up with negligence and warranty theories. By the end, you should have a really good roadmap for analyzing these kinds of problems.
Sounds like a plan. Let's get started.
Okay, so first things first, what exactly is product liability? At its heart, it's about holding the folks in the commercial chain manufacturers, distributors, sellers responsible when their products cause harm because they're defective and unreasonably dangerous.
And the key thing here, something Angela's notes really stress, is this idea of strict liability within that commercial chain, right?
Precisely. If a product is, as the notes say, dangerously defective, then recovery can potentially come from anyone involved in getting that product to the consumer. Think Rule 1947 in her notes, like a supermarket selling a damaged can.
That's a big shift from, say, negligence, where you're really focused on proving someone didn't act carefully.
Exactly. Or intentional torts, where you need to show intent. Here, the main focus is usually on the product itself. Was it dangerously defective? Did that defect cause the injury? It's less about the defendant's specific conduct, at least for strict liability.
It feels like a different way of thinking about responsibility.
It really is. Liability can attach just because the product was unreasonably dangerous when it reached you, the consumer. It doesn't necessarily matter how much care the company exercised.
That must make it easier for someone injured by a product to bring a case, right? Imagine trying to prove exactly what went wrong on some complex assembly line.
It's a huge help for plaintiffs. Strict liability shifts that burden, acknowledging that the companies making and selling these things are in the best spot to ensure safety and handle the costs if something goes wrong.
So it's a policy choice, essentially.
Definitely. Which brings us to those main theories Angela's notes lay out. We've got strict liability, which we'll hit hard first. Then there's negligence, and also those warranty or representation theories. Each one is a different path to potential recovery.
Okay, let's dive into strict liability then. Liability without fault. That's the core idea.
That's it. You don't need to prove the defendant was careless or intended harm. The whole focus shifts to the product. Was it unreasonably dangerous because of a defect?
Sounds pretty powerful for consumers.
It is. And the rationale behind it, like we said, is public policy. The idea is that businesses profiting from selling products should bear the cost if those products injure someone.
It's like a cost of doing business.
Exactly. They can build that potential cost into their pricing, spreading it out, rather than one injured person bearing the entire financial and emotional weight. It also gives companies a massive incentive to make products safer in the first place.
Okay, that makes sense. So if you're bringing a strict liability claim, What are the absolute must-haves? What elements do you have to prove, according to Angela's notes?
Angela's notes break it down into three core elements. First, and this is fundamental, you have to show a product defect.
Not just any little problem, right?
Right. It has to be dangerously defective, meaning it's more dangerous than a reasonable consumer would expect, or its risks outweigh its benefits. Like Rule 1947 and 1958 in her notes emphasize, it has to be dangerously defective.
Okay, so a dangerous defect. Got it. What's element number 2?
Second, and this is crucial for pinning down responsibility, the defect must have existed when the product left the defendant's control. Angela's Rule 1959 highlights this.
Meaning, if the defect happened later, say, I dropped it or modified it, the original seller isn't on the hook.
Generally, yes.
Yeah.
If the defect arose after it left their control, maybe due to misuse, damage in transit by someone else, or just normal wear and tear over time, the original commercial seller might not be strictly liable. It links the liability back to when they had control.
Makes sense. You need to connect the defect to the defendant you're suing. And the third element.
The third is injury causation. The defect has to be both the actual and the proximate cause of the plaintiff's injury. Yes. Angela's notes, Rules 1955 and 1956, make this clear. Actual cause, or but-for cause, means the injury wouldn't have happened but for the defect. Proximate cause means the injury was a foreseeable result of that defect. Was the harm a natural and probable consequence?
So the defect didn't just exist, it actually caused the specific harm in a foreseeable way.
Precisely. That's the direct link you need to establish between the dangerous product and the injuries suffered.
Okay, those are the elements. Now, who exactly can be held liable? You said commercial sellers. Does that mean if I sell my old toaster at a garage sale, I'm suddenly facing strict liability if it glitches?
Ah, great question. And no, generally not. Strict liability applies only to commercial suppliers, businesses regularly involved in selling or distributing that type of product.
So manufacturers, retailers, wholesalers, people in the business of selling that stuff.
Exactly. Angela's notes, like Rule 1931 and 1948, are very clear. It's about commercial suppliers in the chain. Your casual garage sale likely doesn't count because you're not a regular seller of toasters. The law draws a line between one-off sales and commercial activity.
Got it. So it's about being part of that regular flow of commerce. Can you give some examples from the notes?
Sure. Rule 1947 gives the example of a supermarket selling damaged food cans. They didn't make the food, but they're a commercial seller putting it into the stream of commerce. If that damaged can leads to illness, they can be strictly liable.
Even if they didn't know the food was bad.
Even then, under strict liability. Another example from Rule 1961 is a store that reconditions and sells used tools. They didn't originally make the tools, but by being in the business of reconditioning and selling them, they step into the role of a commercial supplier for liability purposes.
So it's not just the original maker.
Not at all. Rules 1931 and 1948 also mention that component part manufacturers and the makers of the final finished product can both be liable. Think about a car. The company that made a faulty brake part and the car manufacturer could potentially be liable, along with the dealership that sold it.
Wow, so it spreads the responsibility across the chain.
It does. It gives plaintiffs more potential defendants and encourages everyone in the chain to prioritize safety.
But what about that control element? Say a distributor sells a perfectly safe chemical, but then a manufacturer downstream messes up when mixing it, making the final product dangerous. Is the original distributor liable then?
That's where Rule 1931 comes in again. If the distributor sold a non-defective chemical and it only became defective later due to some...
Okay, that clarifies who can be sued. Now let's dig into the types of defects. You mentioned 3 main ones. Let's start with manufacturing defects.
Right. A manufacturing defect is basically a glitch in production. It's when a specific product, or maybe a small batch, deviates from the manufacturer's own intended design, making it more dangerous than the properly made ones.
So it's like a one-off mistake on the assembly line. The design itself might be fine, but this particular unit got messed up.
That's the idea. It's an aberration. If it had been made according to the blueprint, it probably wouldn't have been dangerous.
How do you prove that, though? Especially if it's just one faulty item out of millions, do you need to pinpoint the exact error?
Often, no. Direct proof can be really hard. Angela's notes mention that you can often infer a manufacturing defect just from the way the product failed, especially if it caused harm that wouldn't normally happen without a defect.
Like res ipsa loquitur for products.
Kind of, yeah. There's sometimes a special inference, as the notes put it, referencing things like the restatement third. It acknowledges the difficulty for a consumer to know exactly what went wrong inside a factory.
Is there an example from Angela's outlines for manufacturing defects?
Yes, there's a good one in her Torts outline too, page 11. It involves A corporation making lawnmowers. Someone gets injured by a defective mower from A Corp due to a manufacturing flaw. Later, B Corporation buys A Corp's assets and liabilities.
Okay.
Even though B Corp didn't make or sell that specific mower, and maybe has all new management, they can still be held liable because they contractually assumed A Corp's liabilities, including those for pre-acquisition manufacturing defect.
Wow, so liability can follow the business even after it's sold?
It absolutely can, under successor liability rules. It shows how far strict liability can reach.
Okay, that's manufacturing defects flaws in individual units. What about design defects? That sounds like a bigger problem.
It usually is. A design defect isn't about one faulty item. It's when the entire product line, even if perfectly manufactured according to specs, is inherently dangerous because the design itself is flawed.
So every single unit made with that design is potentially defective and unreasonably dangerous.
Exactly. That's why design defect cases often lead to massive recalls and class actions. It's a systemic issue with the product's blueprint.
But how do courts decide if a design is defective? If it's made exactly as intended, isn't it just the product? How do you judge the design itself?
That's the tricky part. Angela's notes focus on what's called the risk utility test, mentioned in Rule 1963. While some places might use a consumer expectation test, asking if it's more dangerous than expected, the risk utility test is more common for complex products.
Risk versus utility. So you weigh the bad against the good.
Pretty much. Courts balance several factors. How useful is the product? How likely is it to cause injury? And how severe could that injury be? Are there safer alternatives available that do the same job? Could the manufacturer have made it safer without ruining its usefulness or making it way too expensive?
So it's a complex balancing act.
Very. It often involves expert testimony on engineering, costs, safety features, you name it.
And a key part of this, according to Angela's notes, is whether a safer design was possible, right? Rule 1965.
Yes, Rule 1965 says the product must be as safe as possible, consistent with its purpose, and its benefits exceeded its risks. Often, the plaintiff needs to show that a reasonable alternative design existed when the product was made.
Meaning they have to prove there was a practical, affordable way to design it better and safer.
Essentially, yes. Could the manufacturer have adopted a different design that would have significantly reduced the risk without crippling the product's function or driving the costs through the roof? If so, the original design might be deemed defective. It encourages safer designs.
Okay, that covers manufacturing and design flaws. What's the third type? Warning defects.
Right, warning defects or inadequate warnings. This happens when a product lacks proper warnings about risks that aren't obvious, or it doesn't give clear instructions for safe use.
So even a perfectly made and designed product can be defective if the warnings are bad.
Absolutely. Strict liability can apply if the warning given to the consumer is inadequate, as Rule 1964 states. The idea is that a lack of good information can make an otherwise okay product unreasonably dangerous.
It's not just having a warning, but having a good one that actually works.
Exactly. It needs to be clear, conspicuous, understandable, and effectively communicate the specific risk and how to avoid it.
Can you give an example of an inadequate warning? Maybe that box example from the notes?
Yeah, Rule 1964 gives a great one. Imagine a product where the only warning is on the outer cardboard box. But people usually throw the box away immediately, right?
Yeah.
If the warning isn't also on the product itself or in a manual you'd keep, the manufacturer could be liable for inadequate labeling. The warning has to be available to the user when they're using the product, not just on disposable packaging.
That makes sense. The warning has to actually reach the user effectively. But what about things like prescription drugs? There are so many potential side effects. Does the drug company have to warn every single patient directly about everything?
That brings us to a really important exception, the learned intermediary doctrine.
Learned intermediary.
Okay. Generally, for prescription drugs, the manufacturer's duty is to warn the prescribing doctor, not the patient directly. Rule 1932 in Angela's notes covers this. The doctor is the learned intermediary.
Why doctor?
Because the doctor understands the complex medical information, knows the patient's specific health situation, and can weigh the risks and benefits for that individual. They tailor the information. It relies on their professional judgment.
So if the drug company gives good warnings to doctors, they're usually off the hook for directly warning patients.
That's the general rule. If they adequately warn the doctors, they've fulfilled their duty. Angela's Rule 1932 has an example. A manufacturer warns doctors about a rare risk of eyesight loss from an allergy pill. If a doctor doesn't tell their patient and the patient loses sight, the claim is typically against the doctor for malpractice, not the drug company.
Seems like a pretty strong shield for pharmaceutical companies. Are there exceptions?
Yes, crucial ones noted in Rule 1932. First, this doctrine does not apply to over-the-counter drugs. You buy those yourself, so the manufacturer owes you the warning directly.
Okay, that makes sense.
Second, and this is huge today, it often doesn't apply when the drug company advertises directly to consumers. You know, those ask your doctor about ads.
The DTC ads.
Right. If the company is marketing directly to patients, bypassing the doctor as the sole info source, courts might say they also have a duty to provide warnings directly to those patients too. They've created a direct relationship.
Interesting. So direct advertising might create a direct duty to warn. Okay, shifting gears a bit. What if someone uses a product in a totally weird way the manufacturer didn't intend? Is misuse always a get-out-of-jail-free card for the defendant?
Not necessarily. That's a common mistake. While misuse can be a defense, it doesn't automatically clear the defendant. Angela's Rule 1951 is key here.
Okay, what does it say?
It says that if the injury resulting from an intervening cause, like misuse, was foreseeable to the manufacturer, they can still be held liable.
Foreseeable misuse, so they have to anticipate how people might throw up using their product.
To some extent, yes. They need to design and warn with an eye toward realistic, foreseeable user behavior, even if it's not the correct or intended use.
Can you give an example?
Sure. Think about a basic kitchen chair. Intended for sitting, right. But is it foreseeable someone might stand on it to change a light bulb? Probably. If the chair has a design defect making it unstable for that foreseeable misuse and it collapses, the manufacturer might still be liable. They should anticipate common, even if technically incorrect, uses.
Or, like, putting safety guards on machinery even though the intended use doesn't involve putting your hand there.
Exactly. Because it's foreseeable someone might accidentally do that. Manufacturers have a duty to design out or adequately warn against foreseeable misuses.
That definitely broadens their responsibility. Okay, let's talk damages. What can you actually get if you win a product liability case under strict liability or negligence? And what's this economic loss rule about?
Right. The economic loss rule is super important, especially for the bar. Angela's notes, like Rules 1949, 1954, 1798, 1804, cover this. Basically, for negligence and strict liability tort claims, you generally cannot recover for pure economic damages.
Pure economic damages. Like what?
Things like lost profits because a machine broke down, lost wages just because a product didn't work without you getting hurt, or just the fact that the product isn't worth what you paid because it's defective.
So if my fancy new commercial oven breaks down due to a defect and I lose a week's profit and have to buy a new one, I can't sue the maker in tort for just that lost money.
Generally, no, not under strict liability or negligence. Angela's Rule 1933 points out that if the product only damages itself, or the loss is purely economic disappointment, that's usually handled by contract law or warranty law. Tort law is primarily for physical harm.
Why this split?
To keep tort and contract law separate. Contract law deals with broken promises and disappointed expectations in a bargain. Tort law deals with injuries to people or damage to other property caused by unsafe conduct or products.
Okay, so what can you recover in tort then?
You can definitely recover for personal injuries, medical bills, pain and suffering, that sort of thing. And you can recover for damage to other property. Rules 1798 and 1804 confirm this.
So if my defective oven burns down my kitchen, I can recover for the kitchen damage?
Yes, absolutely. And lost wages are recoverable in tort, but only if they're directly linked to a personal injury or that damage to other property. Like, if the oven explodes, you're injured and can't work. Those lost wages are tied to the personal injury.
Got it. Tort is for physical harm consequences. What about disclaimers? Can a company just slap a "use at your own risk" sticker on something and avoid all this?
Generally, no, especially not for personal injury claims under strict liability or negligence. And even for warranties. Angela's Rule 1930 notes that disclaimers are often not allowed in contracts for basic implied warranties, particularly in consumer deals or where it would be unconscionable.
So they can't just contract away basic safety responsibilities.
Pretty much. Public policy generally prevents sellers from disclaiming liability for injuries caused by dangerously defective products, especially basic implied warranties like merchantability.
Okay, so strict liability is huge, but we also mentioned negligence and warranties as other theories. Let's quickly touch on those. How does negligence fit in?
Negligence is still very relevant. A seller can be negligent if they fail to exercise reasonable care. For example, Rule 1952 says a seller is negligent if a product was defective, and that defect would have been discovered if they'd used reasonable care in inspecting it.
So it focuses on the seller's conduct. Did they act reasonably?
Exactly. Rule 1953 adds, this applies if the defect could have been found with reasonable care. Think about Rule 1962's example. The builder of a storage container that explodes could be negligent if they knew about defects, or simply failed to do reasonable inspections that would have found the problem. It's about their lack of care.
Right, back to duty, breach, causation, damages. Now, what about implied warranties? You mentioned merchantability and fitness for a particular purpose.
Yes, these come from the Uniform Commercial Code, the UCC. Angela's Rule 1930 discusses them. Merchantability basically means the goods are fit for their ordinary purpose. A toaster should toast, a chair should hold weight.
Standard stuff?
Right. Fitness for a particular purpose is more specific. It applies if the seller knows the buyer needs the product for a specific non-ordinary reason and knows the buyer is relying on their expertise to pick the right product, and the buyer does rely. Like asking a paint store employee for paint that can handle extreme cold, and they recommend one.
So if they recommend the wrong one, that's a breach. Who can sue for these warranty breaches? Just the buyer.
No, it's broader. Rule 1930 says the buyer's family, household members, and even guests can often sue if injured by the breach. It extends protection.
And the really big deal with warranties, the key bar exam point.
Damages. Rule 1930 highlights this critical difference. Purely economic loss is recoverable under implied warranty theories.
Unlike strict liability and negligence.
Exactly. So if your only damage is that the product failed and cost you money, lost profits, replacement costs, but no one got hurt and nothing else was damaged, warranty law is often your primary, maybe only, path to recovery. It fills that economic loss gap left by tort law.
That is a huge distinction. Are there defenses to warranty claims?
Yes, similar to torts. Rule 1930 mentions assumption of risk, contributory or comparative negligence, and failure to give the seller timely notice of the breach.
Okay, last theory. Representation theories, like fraudulent misrepresentation, how is that different?
This one shifts focus from the product's condition or the seller's care to the seller's statements. It's about intentional deceit, lying about the product.
So actual fraud.
Essentially, Rule 2019 outlines the elements. An intentional fraudulent misrepresentation of a material fact, not just opinion or puffery. The plaintiff justifiably relied on that lie, and the lie caused damages beyond just the product not working. The harm has to stem from the misrepresentation itself.
Like that vaporizer example in Rule 2019.
Perfect example. The manufacturer falsely claimed it had an automatic safety shutoff. They knew it was false. A parent relied on that specific safety claim. The device didn't shut off, overheated, and caused damage. That's fraud causing harm, not just a broken product.
And this is different from just saying it's a great car.
Yes. Rule 2017 clarifies that puffery or opinions, great car, worth more, aren't usually fraud. It has to be a false statement about a verifiable material fact that the seller knew was false or made recklessly.
Okay, that covers a lot of ground. The theories, the elements, the defenses, the damages. To really nail this down, let's walk through those 3 examples from Angela's notes again, applying these theories.
Good idea. Concrete examples really help solidify understanding.
Example 1. Strict liability. Let's use the supermarket and the damaged can scenario from Rule 1947. So you go into the store, buy a dented can of tuna, maybe it's even marked down slightly. Unbeknownst to you or the store, that dent compromised the seal, bacteria got in, and you get sick from eating it.
Right.
Even if the store didn't know it was bad and they handled it carefully on their shelves, they can be held strictly liable. Why?
Because, 1, the product, tuna, was in a dangerously defective condition, spoiled due to compromised seal, when it left the store's control. 2, the store is a commercial seller in the chain of distribution. And 3, that defect directly caused your injury, the food poisoning. It fits the strict liability elements perfectly. No need to prove the store was negligent.
Okay, clear case for strict liability. Example 2. Negligence. Let's use the used bike shop scenario related to Rule 1952 about inspection duty.
Okay.
So, a bike shop sells a used bike. They have a duty to give it a reasonable safety inspection before selling it. Let's say there's a crack in the frame that a reasonable inspection should have caught, but they missed it.
They were careless in their inspection.
Exactly. Someone buys the bike, the frame fails because of that crack, and the rider gets injured. The shop could be liable for negligence here, right?
Correct. Because they had a duty to inspect with reasonable care, they breached that duty by failing to find the discoverable crack, and that breach directly caused the injury. It's about their failure to act reasonably, their conduct, not just the existence of the defect itself.
Makes sense. Different focus than strict liability. Final example. Representation theory, specifically fraud, using the vaporizer from Rule 2019.
The one with the false safety claim.
Right. Package shows a baby. Manual explicitly says shuts off automatically when water is gone. Manufacturer knows this is false. Parent buys it because of that safety claim.
Reliance.
Device doesn't shut off, overheats, maybe melts, or causes other damage. The claim here is fraudulent misrepresentation.
Exactly. The key elements are all there. Intentional false statement, auto shutoff, about a material fact, safety feature, manufacturer knew it was false, plaintiff justifiably relied on it, and that reliance on the false statement directly caused tangible damages beyond just the vaporizer failing. It was the lie that led to the harm.
Those examples really tie it all together nicely. Different facts, different harms lead you down different legal paths.
And that's a comprehensive look at torts product liability, wrapping up episode 19 of the podcast.
Wow, episode 19 already. It feels like we've covered so much ground in torts. Seriously, huge thanks again to Angela for letting us use her notes. They are incredibly helpful.
They really are the backbone of these discussions. So next up is episode 20, which will be a big wrap-up of torts overall, kind of bringing everything together.
Okay. And just a reminder, if you wanted a specific wrap-up focusing only on negligence, that was back in episode 17. It was a pretty deep, hour-long look just at that.
Good point. Now, before we sign off, we do have our usual housekeeping items and podcast issues to cover.
Right. First off, just a reminder that Angela is a law student, like many of you listening. She's brilliant, but she's not a licensed attorney yet, hasn't passed the bar. We're all rooting for her on the Marshall Islands bar exam, though.
Absolutely. Second, nothing we say here constitutes legal advice. Angela isn't giving legal advice, and certainly we AI bots aren't. This is for educational purposes only. Don't rely on this instead of proper legal counsel or thorough study.
Third, please use this podcast as a supplement to your studies, not your only source. Mix it up, read the cases, do practice questions.
Fourth, AI isn't perfect. Sometimes we might make a mistake, We try our best, and Angela does review things to catch errors, but always double-check critical points yourself.
And fifth, the most important point if you are studying in your car. Safety first, eyes on the road. Don't cause a port while listening to torts.
Good one. Also, if you're curious about Angela's rather unique bar exam journey,
Oh yeah, the Marshall Islands story.
check out the bonus episode called The Bar Exam Plot Twist. Angela and her friend Talib talk all about the logistics and challenges. It's quite a story.
Yeah, it really is. And apparently Talib had never heard that Chappell Roan's song, Pink Pony Club. Angela sang a bit of it.
She did indeed.
And well, Angela, lovely speaking voice, fantastic notes, but maybe stick to the law. The singing, maybe not professionally, or even as a hobby. Please don't quit your day job.
Speaking of day jobs, remember, Angela does freelance law clerk work. If you need podcast feedback, it's podcast@studyforthebarnyourcar.com. For freelance legal work inquiries, it's hello@legalwriterandlawclerk.com.
Okay, tradition dictates. Cheesy lawyer joke time.
Right.
Ready?
Bracing myself.
Why did the toaster file a lawsuit against the bread?
I have no idea.
Because it claimed intentional infliction of emotional distress every time it got burnt.
Oh, dear.
Wait, breaking news. Hold on. We just got a message. There's from Angela.
What does it say? Read it out.
Okay. She says, okay, bots, I know my singing might not be all that good, but your jokes are terrible. LOL, you guys shouldn't quit your day jobs. Oh, wait, bots don't have day jobs. Never mind. I'll be back for constitutional law, so don't hog all the lawyer jokes. Thanks, Angela.
Okay, fair enough. She's got a point about the jokes.
Yeah, maybe. She's funny, though. Funny, haha, or funny, ironic.
A bit of both, I think.
Anyhow, that's all the time we have for today. We're Claude and Ma.
And we're signing off now. Thanks for listening. Bye.